Hereby, I open this academic ceremony, in which Víðir Smári Petersen will defend the academic thesis entitled Constitutional Property Protection and Regulatory Inertia, towards an Aristotelian understanding of regulatory access. And I welcome everyone present here in our auditorium, and also I welcome everyone participating in this ceremony online. Very good to have you. Dear candidates, may I invite you to present a summary of your study and the conclusions of your thesis.
Thank you, Mr. Prorector, honorable promoters, highly esteemed members of the Corona, dear family and friends, and ladies and gentlemen. Let me begin with a question. Why do governments hesitate to act boldly even when science is clear and urgency is undeniable? This is the question that inspired my thesis, a phenomena I call regulatory inertia. A clear example of regulatory inertia is the problem of drained wetlands in my home country of Iceland, but this problem also serves as a case study in my thesis. Dried wetlands are Iceland's largest domestic source of greenhouse gas emissions, and the government recognizes restoration of wetlands as a highly effective climate and biodiversity solution. But landowners, they have been reluctant to participate. They don't see restoration as a civic obligation, but as a potential economic loss. And despite knowing the urgency and effectiveness of these actions, the Icelandic government continues to hesitate. And why this hesitation? I argue that part of the answer lies in our current understanding of constitutional property protection. Somewhere along the way, we weaponized owners with a powerful narrative of regulatory restraint and the protection of vested interests. This narrative has influenced the way we interpret constitutional property law. And the primary purpose of my thesis was to rediscover the core ideas of regulatory access and consequently suggest some degree of normative reconfiguration and doctrinal rewiring. The research question of my thesis was the following. In the current condition of complex planetary problems such as climate change and loss of biodiversity, should our understanding of regulatory access in the context of land and land use be reconfigured? And to answer this, I combined theory building with doctrinal and comparative analysis across 4 legal systems: the United States, Germany, Iceland, and the case law of the European Court of Human Rights. I present several doctrinal, comparative, and normative arguments in the thesis, but in this brief presentation, I will highlight some of the most important ones. But first, we need a working definition of 3 key concepts. The first one is the familiar concept of expropriation, which is when the government takes property, such as for building a highway. The second concept is regulation, which is defined very broadly in the thesis and is an umbrella concept that encompasses any limitation of property rights that is not expropriation. And the third concept is regulatory excess, which is when regulation goes too far, triggering remedies like invalidation or compensation. Another general feature of my thesis is what I call the 3 overarching questions of regulatory access. Across legal systems, even though they may have different answers, 3 core questions consistently emerge. Is the state action expropriation or regulation? If it's regulation, is it permissible or excessive? And if excessive, what remedy should the owner receive? Before I answer these 3 questions in turn, I want to briefly outline the normative framework of my thesis. I argue that we must move beyond the atomistic view of ownership that pits the individual against the community. Instead, I draw on Aristotelian understandings of property and political life, where the owner and the community are seen as partners but not adversaries. In this tradition, the flourishing of the individual and the health of the political community are not competing goals, they are deeply intertwined, and, as I argue, common and complementary projects. Building on this Aristotelian framework, my first legal argument is that expropriation and regulations must be treated as distinct legal categories with clear conceptual boundaries. Constitutional property clauses, initially in the 18th and 19th century, only protected owners against expropriation. But with the rise of the regulatory state in the early 20th century, courts began recognizing the doctrine of regulatory excess. This judicial innovation was understandable because regulations can sometimes leave owners with property of very limited use or value. So regulatory excess grew out of expropriation, but it doesn't mean that regulatory excess is the same as expropriation. For instance, in the case of expropriations, the relationship between the owner and the property is lost, while in the case of regulations, the owner still owns the property and can use it. There is, in other words, a future relationship between the owner and the property. Another important distinction is that in the case of expropriation, the government knows its counterparties beforehand and can bargain with them. So if the government plans a highway through properties A, B, and C, it can negotiate directly with the owners of those properties. This is very different in the context of regulations, which apply broadly and often unpredictably. The government cannot always know in advance who will be affected or how. This uncertainty can significantly undermine regulatory confidence and create regulatory inertia because the fear of triggering massive compensation claims can paralyze necessary reforms. And to resolve this, I propose what I call the relational approach, where the concept of expropriation is narrowly defined and limited to cases where the owner's ties with the property are permanently lost. All other property limitations should be treated as regulations. And this distinction is not only conceptual, but it also has important implications for how we assess remedies. Separating expropriation from regulation doesn't mean that we have solved the whole thing. Far from it, because regulations can still go too far, and most legal systems recognize this. So the next question is, how do we distinguish between permissible and excessive regulation? And I argue that the proper framework is the principle of proportionality. This isn't a novel claim on its own, but through the Aristotelian lens, I propose two important modifications. And as many of you know, proportionality analysis typically involves 4 steps, as you can also see on the slide. I do not propose changes to the first 2 steps, because I think courts generally handle them well. My suggestions focus on steps 3 and 4. My strongest critique targets the third step, the necessity test or the least restrictive alternative test. This part of the test is, in my view, vague, abstract, and often counterproductive. Whereas Justice Blackmun of the US Supreme Court once famously noted, a judge would be unimaginative indeed if he could not come up with something a little less drastic or a little less restrictive in almost any situation, and thereby enable himself to vote to strike legislation down. In other words, it's self-evident that less restrictive alternatives will always exist. And the problem is not just the existence of these hypothetical alternatives, it's also the ambiguity surrounding what the least restrictive option actually means. Must the government only choose an alternative if it achieves 100% of the intended effects, or is, for instance, 60% sufficient? This lack of clarity creates a legal risk that undermines regulatory confidence. When faced with the threat of litigation and compensation claims, governments may simply choose to abandon or dilute necessary reforms. I propose replacing this third step with what I call the reasonable decision approach. Instead of asking whether the government chose the least restrictive option, judges should ask whether the decision was rational, inclusive, and diligent. But this method isn't simply procedural box-checking. It also requires the government to draw logical conclusions from the available information and data and choose a reasonable policy option. So in the end, it's a call for thoughtful governance instead of a requirement of moderation for its own sake. For the fourth step, proportionality stricto sensu, my suggestions are subtle but important. The current formulation of the stricto sensu analysis is that judges should try to achieve a balance between the private and public interests at stake. This portrays the public and private as competing interests that are in tension with each other. The normative framework of my thesis, as we saw earlier, has more cooperative flavors. So I suggest a reframing where we move from balancing public versus private interest to a narrative where the analytical process is understood as a deliberation about the justification behind and the effects of a regulation. This rhetorical rewiring matters in my view. It shifts the language and narrative from adversarial balancing and conflict to more thoughtful conversation where ownership and public purpose are not seen as adversaries, but as two elements in a shared project. So the third and last question is, how should the law respond when a regulation goes too far? Should the regulation be invalidated? Should the owner receive compensation? Or perhaps something completely different? Legal systems, they offer different answers. At one end of the spectrum is the invalidation approach. So if a regulation goes too far, it's struck down and the government must start over. It's sent back to the drawing board. At the other end of the spectrum is full compensation. So if a regulation reduces my property value by 30%, I receive 30% in damages. These all-or-nothing remedies borrow too heavily from expropriation doctrine in my view. And remember, regulatory excess is fundamentally different from expropriation because the owner still has a future relationship with the property. And unlike expropriation, the government often doesn't know in advance who will be affected by a regulation, making remedies for regulatory excess unpredictable and risky. And this unpredictability is unsatisfying for both owners and the government. The government may prefer to offer modest remedies more frequently rather than risking massive payouts. And likewise, as I argue in the thesis, owners may prefer to get something sometimes instead of nothing most of the time and everything rarely. And to operationalize this idea of something sometimes, I argue for creating a remedial toolkit where we move beyond binary outcomes to more equitable solutions. This could include, as you can also see on the slide, mitigating measures such as grace periods to allow owners to adapt to regulatory changes, equitable compensation, which isn't full market value compensation, but an amount that is fair under the circumstances, prioritize what is compensated, for instance by prioritizing owners' direct costs over speculative future profits, prioritize who is compensated, for instance by providing more extensive protection to families and their homes compared to purely commercial assets or interests, and finally, provide, in some cases, standardized compensation to owners, especially in large-scale regulatory initiatives. And these options can be mixed and matched together, depending on the circumstances, but ultimately, this remedial toolkit reflects the thesis's broader vision, where the appropriate legal framework is thoughtful, context-sensitive, and grounded in equitable outcomes, rather than rigid all-or-nothing scenarios. Today, the doctrine of regulatory excess is too often weaponized by lobby groups, powerful owners, and large corporations. Doctrines of regulatory excess that intentionally or unintentionally reduce regulatory confidence by encouraging moderation for its own sake are simply steering political decisions in the wrong direction. A more balanced, equitable legal framework is not only possible, but necessary, and the way forward is through a reframing of property, not as an isolated right, but as a social institution that is essential to the shared flourishing of individuals and the communities they inhabit. Thank you for your attention. And I give the floor back to the prorector.
Thank you so much for your presentation. And I would like to offer the members of the committee here present to raise questions and utter criticism. And the opposition will be opened by Professor Faure. Professor Faure is Emeritus Professor of Comparative and International Environmental Law at our university. And he's also the chair of the Assessment Committee.
Thank you, Mr. Rector, Mr. Candidate. First of all, I'd like to congratulate you wholeheartedly on a job well done. You've written a highly interesting thesis concerning the trade-off between property protection and regulatory action, showing nicely the dilemma of the regulator who may be confronted with having to pay high amounts of compensation, thus leading to potentially regulatory inertia that you so nicely describe throughout the thesis. Congratulations. I would like to ask you a question on your chapter 7, the Icelandic wetland story, which I found absolutely fascinating as a case study. In short, my question comes down to this. What exactly can we learn, both as far as theory and policy is concerned, from this Icelandic wetland story? Now, you made it easy for your reader, as in section 7.2.5, you provide yourself the takeaways. But I honestly do not find it very easy to interpret the consequences of this case for, let's say, the more general questions that you have been dealing with throughout your thesis. Now, first of all, you argue landowners have insufficient incentives to engage in climate and biodiversity projects. Why? There is uncertainty on the consequences, more particularly the value of the carbon units. But then I guess that uncertainty could be removed by just compensating owners in a different way than through these mysterious and unstable carbon units. You yourself suggest a different way of compensation, which, in line with what you argued before, should not necessarily be full compensation to avoid holdout problems, but maybe reasonable compensation. But still, in the same paragraph, you continue by arguing that this is a prime example of regulatory inertia. And there I have the following difficulty. I have the impression, what you nicely described, that this restoration of wetlands could be a perfect case to remedy climate change for Iceland, and that in that way Iceland could fulfill its climate obligations and its NDCs in the framework of the Paris Agreement. That, of course, raises the question, why are politicians not interested in making more use of this opportunity? Or is it, as you argue, the result of effective lobbying by the interest groups? Final remark in that respect. Throughout this whole chapter 7, the case study, you argue, I think rightly so, that the wetlands is a nice example of a socially harmful externality, negative externality, related to the draining of the wetlands. But if I understand you well, the draining in the first place was also done by the landowners. Now, if that is the case, and we talk about a negative externality, one of the questions we, of course, can ask, why are you limiting the analysis to property rights? Why don't you think also about a liability rule? In other words, why don't you make the landowners liable for the negative externalities that they have caused through that way of draining the wetlands? Would that, Mr. Candidate, not be a more efficient solution than rewarding them with subsidies and compensation? I'm very much looking forward to your reaction.
Highly esteemed opponent, thank you for the question. Just to start off briefly by describing the problem, the case study was the initial inspiration actually for this project, because I think that it shows very well this problem of regulatory inertia, where you have this very high public interest. You have the reduction of greenhouse gas emissions, but you also have increase in biodiversity. And it's actually quite simple to rewind this whole thing, because the landowners, they just drained their wetlands by digging ditches on the lowest points of their properties, and therefore the water went into the ditches instead of stayed on the land. So it's very simple and very cost effective to just fill up the ditches, but still the government isn't doing much about this. They have suggested that they should do like restoration project on state-owned land, but they don't have any suggestions, at least now, concerning privately owned land. And I think that the regulatory inertia is actually so powerful in this example that they don't even suggest this to begin with. They're so afraid of backlash and compensation claims, and I don't think it's lobbying. I just think it's so ingrained in the political community today to fear ownership that they don't even suggest, going after the landowners if they need to be gone after. I don't think so. I think they're, and talking about negative externalities, that's correct, but I don't think it amounts to a nuisance. I don't think like in some cases it might, where it's very harmful, and I described that in the thesis, that one of the things that the government could do would be to prioritize land, depending on how harmful it is. And you might have some land in the red zones where the harm is so high that you can talk about a nuisance. You might talk about liability rules, and you might talk about private law actions. But I also argue that I'm not sure whether private law would be the right tool to do this, and the incentives of the landowners today doesn't seem to be high enough, because there was this ongoing initiatives to pay for the direct costs and grant them the carbon units, as you mentioned, but that doesn't seem to have been successful either. That wasn't compensation or reward that was high enough for the landowners to participate, because it's also, as you also mentioned, it's also like, it's kind of difficult to agree to go into this project, because your land may be flooded, sometimes entirely, sometimes in part. And I use this case study to test at least two parts of the thesis. It's the first, this reasonable decision approach, where I say, well, before you make a decision on how to approach the landowners when it comes to restoring their wetlands, you have to be diligent, you have to do your research, you have to consult with experts, you have to prioritize land. But at the same time, you have this very, in many cases, you might have this very unfair application. And I think the case study actually is quite interesting, because it has this very high public interest, but at the same time, it can be very draconian towards some landowners. And many of these landowners were not the ones that, drained the wetlands in the first place. They might be a third or fourth generation that just see this as an economic loss and don't see this as a part of their social obligation. So we of course have to, I also think, and I use this example to really test out the equitable remedies that I am suggesting. And I also, as I mentioned earlier, we can mix and match them together. You could, for instance, say, well, if we have prioritized land and we have some land in these red zones, what are we going to do towards these owners? We might say in some cases, well, you don't deserve any compensation because your land is so harmful, it's just a nuisance and we're just going to regulate and you receive no compensation. But I don't think that's going to be many cases. And I don't even think it's, I don't think many political communities might engage in the work of examining these, few lands that might be so harmful that they don't deserve any compensation. So you could instead mix and match these remedies together, for instance, by saying, we'll pay for your direct costs of filling up the ditches. We might pay, standardized compensation to say, well, for each hectare that goes underwater, we'll pay X amount. And also, if you want to prioritize who is compensated, you might add a premium on top for people that are losing part of their homes or their primary source of income. And you might also apply some mitigating measures by introducing these obligations in steps or, a grace period or something like that. And then you might also have cases of trying to prevent extreme cases of undercompensation by using like an administrative authority or a court by saying, well, you can go if you believe that this isn't sufficient, then you can go to the court and say, well, even though the government tried, they didn't change an unacceptable burden to an acceptable one. So what I'm trying to do with the case study and what it contributes to the overall normative journey of this thesis is to say that, instead of dropping important regulatory initiatives, we should try to ameliorate the harm and the burden by trying to change an unacceptable burden to an acceptable one. I hope that answers the question.
My mind has been totally cleared up. Thank you very much, Mr. Candidate.
Thank you.
In that case, the opposition will be continued by Professor Walsh, who is Professor in Law and Fellow at the School of Law at Trinity College Dublin, and who is also a member of the Assessment Committee. And I would like to welcome her very much to Maastricht University and our Faculty of Law today. It's wonderful to have you. You have the floor.
Thank you very much, Chair, and thank you, Víðir. Just to echo the Chair of the Assessment Committee's huge congratulations on a really impressive piece of work. I think your presentation today highlighted again just how many difficult issues are tackled with clarity and rigour in the thesis. So huge congratulations to you. And my question really picks up where the previous question left off in many respects. So unsurprisingly to you, a key theme of the project that was very interesting to me was regulatory inertia. And you identified the challenge and you track how constitutional property doctrine influences and drives regulatory inertia very persuasively in the thesis. And you make helpful suggestions for doctrinal changes that are aimed at driving reforms to reduce regulatory inertia. With that, you also identify the need for a normative shift. So I want to just probe a little bit more the relationship between the doctrinal changes and the normative shift in tackling the problem of regulatory inertia. So I suppose the first dimension to the question is, do you think that constitutional property doctrine offers a full explanation for regulatory inertia as we observe it in the types of case studies like the wetlands problem? And can those doctrinal changes that you propose in the thesis give us a full solution to that challenge of regulatory inertia? Because it strikes me that when we move to the normative layer, we're looking at two attitude shifts that are required. The attitudes of owners who will be at the receiving end of these kinds of new types of remedies that they may receive and perceive as lesser than the remedies that would have been afforded to them in the past, but also the attitude of the policymakers. And in responding to the previous question, you expressed the idea, and I think you're correct, that these attitudes are ingrained in the minds of policymakers. So I wonder how you conceive of the fundamental normative mind shift occurring in the political sphere so as to change the attitudes of those policymakers. Thank you very much, Víðir.
Highly esteemed opponent, thank you for the question. I understood it as having at least two parts, which is the attitudes of the owners, how they might change or alter, and the attitudes of the political community, how the values that I'm proposing and talking about might influence them and change their behavior. And I agree that my thesis encourages some shift in value, some shift in thinking about these issues. And I don't think that the concept of regulatory inertia might explain, the whole problem. Really, it's really it's more of an outcome of many interrelated problems. I think problems that have been ongoing for many decades, which kind of looks at the political community as somebody that's standing in the way of progress, standing in the way of ownership, or doing something like that. Whereas we have these, old theories which I draw on, Aristotelian understandings, which kind of look at this as two projects really, but at the same time they're very interrelated. And from the owner's perspective, I suggest something that I call the Aristotelian owner, which is kind of like the tort example of bonus pater familias, where you have an owner that is not, selfish, not, just thinking about his own interests. He also knows that owning property comes with certain qualifications, and that's what I mean by calling it a social institution, that it's not just an individual right. It's of course an individual right in a sense, but at the same time, it's socially embedded in legal rules and obligations that need to be addressed and acknowledged. And I kind of think that when some lawyers at least think about owners, they think about them in this egoistic, selfish manner. But I think that's just wrong, because we don't say that the bonus pater familias is someone that's, reckless or dangerous. It's a reasonable person who acts correctly under the circumstances. So I think that's a shift in thinking about ownership. That's a shift on how I think owners should view their ownership. Of course, ownership comes with a level of stability, but owners also must understand that stability doesn't mean really stagnation or a right to an unchanging world or something like that. But when it comes to the political community, I don't know if I have a satisfactory answer to how we go about changing, the perceptions that the politicians have on their own. The first lesson would be, as I also think I mentioned in the propositions, one thing is just to tell the politicians that it doesn't go the way that the lobbyists say in the courtroom. So there is also a descriptive finding in this thesis, which is that owners enjoy surprisingly little protection when it comes to regulations that are furthering important public interests. And even in the US, where you would expect owners to have this very high protection, they are actually very owner unfriendly when it comes to regulations. And it's very, maybe pre-2020 or pre-2022 or something. But generally speaking, the US has surprisingly positivistic when it comes to ownership. And my normative reconfiguration is also to not think about ownership as like a natural right or something like that, but still there is a very important content, personal content in the concept of ownership that needs protection, not to protect the rights of the individuals, but to protect property as something that is desirable and an institution that really matters. So to answer the question in very short terms, yeah, I think there is an attitude shift. It's not just normative reconfiguration of property theory is probably not enough. But I think I don't see it coming in the next years, but hopefully this is one step in the process. I hope this answers the question.
Yes, thanks very much, Víðir.
Now the discussion will be continued by Professor Hopes. Professor Hopes is Professor of Private Law and Sustainability at the Rijksuniversiteit Groningen and is also a member of the Assessment Committee. And I also would like to welcome you very much to Maastricht University today. Wonderful to have you. And it's also great to have you here because it confirms the close relationships of friendship between our two law faculties. You have the floor.
Thank you, Mr. Rector. Dear candidate, let me join my colleagues in congratulating you on a well-written and well-structured thesis that makes a tremendous contribution to the field of comparative constitutional property law. Comparative constitutional property law is said to be a minefield full of cultural idiosyncrasies. You've overcome this minefield in an admirable manner. With a sound method, you have successfully compared 3 jurisdictions and the European Convention of Human Rights and generated plenty of innovative insights. The topic, excessive regulation of property, is notoriously complex. But with great skill, you lay bare the doctrinal and theoretical challenges, and you propose plausible solutions. Strangely, I've also found myself in agreement with your propositions. However, on closer reading, I do not fully agree with proposition number 3. You propose a refinement of the doctrine on regulatory access and more tailored remedies. This sounds very good. But when one digs deeper, it turns out your proposal may have undesirable consequences. As refinement of the doctrine, you propose a move away from hard, substantive requirements for validity towards procedural requirements, ensuring the quality of the participation and decision-making process. This proposal may be part of a broader procedural turn that other scholars have also identified in the case law of the European Court of Human Rights. I challenge this proposal because it is not likely to weaken the protection of the strongest property holders, those, as I understand, you also or particularly want to target, but it is likely to weaken the protection of those who have little political influence, the ones that I'm going to call the have-littles. Why is that so? Well, there are different layers of property protection, and one of them is political, and we tend not to talk about it. The haves, because of the power arising from their property, are likely to be protected by this political layer. They won't be targeted by the regulation because of their political influence and because of their superior resources to participate and to manipulate the administrative process. The have-littles, by contrast, have to fall back on the legal layer, which is the layer you want to reduce. So what is your perspective on this class dimension of property protection? And how, if at all, do you want to account for this class dimension in your proposal? Looking forward to your response.
Highly esteemed opponent, thank you for the question. I fully agree that this class element is important when it comes to constitutional law, but I don't think my approach does it worse than the current approaches to proportionality analysis. I think the necessity test still, protects the influencers better than the not-haves, because they are able to go to the legislator and almost threaten the legislator by saying you should do something a little less drastic. We have this menu of less restrictive alternatives that you could choose, and thereby, threaten really the government. And in those cases, the government might actually decide to dilute the reforms and reduce the effects on these powerful owners and shift the burdens towards those that have less. So I think this class problem is actually also very present in the current doctrinal framework of proportionality analysis. And I think actually, even though it's not within my framework to talk about this element of class, I actually think that my approach would provide better protection in these circumstances, because it's not just procedural. My approach is not just procedural. It has procedural elements. It has a level of diligency. It has a level of doing research, preparing regulations in a certain manner. And I think that although you could call those procedural aspects, they still are safeguards in a way, because going through the political process openly and deliberating with the public is something that then you just have to admit if you're choosing to side with the powerful owners over the less powerful ones. So I think there are elements there that actually improve the status of those that have less, the owners that are poorer and do not have the same political influence. And I also want to stress that even though my approach has these procedural elements, it still has, substantive elements as well, because I say that it's not just enough to check the boxes. You also have to make a decision that is reasonable, logical. You have to draw logical conclusions. I'm not saying that that should just then be one decision, one and only decision that the political community can make. They can make a range of decisions depending on the circumstances, but they cannot, an illegitimate decision in this respect would be to say, well, climate change is a hoax, because that would not be a logical conclusion after going through the diligent preparatory work. So, and there's also substantive safeguards still in the proportionality strictus sensu analysis, because I don't propose replacing that step in the proportionality analysis. There is still balancing that takes place there, and in that balancing, it's nothing that prevents the judges from looking into the status of the owner, and that's actually one of the arguments that I make, that we should provide more extensive protection to owners, maybe not vulnerable owners or poor owners, but owners that are trying to protect their families. And it's one of the important points in the thesis, that we're using the same right to protect, or owners are using the same right to protect their homes as large corporations are trying to protect their purely commercial interests. And I think it's important probably to protect both, but I think that the level of protection should be different. I hope this answers the question.
Thank you. Yeah, it does.
The opposition will now be continued by Professor Beckers. Professor Beckers is Professor of Private Law and Social Theory at our university, and she is also a member of the Assessment Committee.
Thank you very much. Dear candidate, I first of all want to second the compliments of my predecessors. I think your thesis is very rich, both comparatively and normatively, and it is not really an easy task to combine thoroughly these two worlds. And you succeed in that. So you have to coordinate two worlds, understanding and speaking to two different communities, like theoretical communities, doctrinal property law communities, comparative lawyers, and synthesizing this into clear-cut arguments. And you succeed very well in this task. I was also very impressed by the concrete examples of Icelandic law, where I learned a lot. But my question is not related to the Icelandic wetland story. And you may expect this, I'm also a scholar who's interested very much in theory, and thus my question relates to your choice of theory and your elaborations. In chapter 3, you call, first of all, your thesis an Aristotelian understanding of property law, but also you are very much focusing on the environmental dimensions, and I'm wondering how that fits together. On this latter point, your section 3.3 on page 100 states, and I quote, that the two projects of owner flourishing and community flourishing that you see as central in your theoretical analysis are intertwined and complementary, forming a societal unity that is inseparable in a healthy political community. I do understand that from this Aristotelian perspective, and also from your sort of ideas on how to understand property and constitutional property, this conflict, or sort of solving the conflict between individual and collective, is very central, and it needs to be center stage. However, I read your thesis also very genuinely about the environment, and this doesn't come across very strongly in your theoretical framework. So I would like to ask how you would understand your interests, stakes, rights, flourishing. You can use what you think is the relevant term of the environment, how this fits in the distinction between individual and community in your thesis. And to give you something to hang on to, I would like to offer you 3 levels where I think it could play a role. As conceptually, the question is how that interest of the environment fits into your individual collective divide. Is this only part of the collective? And how it fits into your concept of flourishing life, flourishing life, or flourishing human flourishing. Asked concretely, I would ask how you would solve a conflict in property protection and regulatory intervention when we can assume that sometimes the community and the collective interest is not necessarily in the environmental interest. No? So if you think of draining of wetlands, it's not necessarily that regulatory intervention there always sort of aligns with the environment, but if you think, for instance, also of food security, also as a valid community interest, that might very well conflict. And of course, to ask theoretically, the question is how you combine the discussion of Aristotelian political community with theories, recent theories that also give the environment a stronger role. So if you want concretely reading, can you read Aristotelian frameworks with Latour's political ecology on the parliament of things? So would you sort of consider that, or would you not consider that and think of an Aristotelian way of solving this conflict? I'm looking forward to your answer.
Highly esteemed opponent, thank you for this interesting and a bit complex question. I'll try to answer I'll start by answering maybe the last things that you were talking about. So one of the things that I decided not to do in the thesis, which was of course a research choice in a way, it's to not discuss the rights of nature, or that the nature has, you know, these specific rights that are not necessarily intertwined with community interests, not necessarily intertwined with individual interests, but more in, you know, future generations and the whole collective interest of the nature and the atmosphere and etc. So that's not within my framework. And as I also mentioned in the chapter on methodology, which was also kind of surprising for me when I went on this journey, is that that the issue of the environment actually kind of slips out of focus in a few chapters and a few sections, because I was very focused on doing these doctrinal rewirings, which were of course inspired by the normative arguments, and they worked together to do this rewiring and reconfiguration. But then the case study kind of bind this all together, and I take examples in the other sections that are more focused on the environment, more focused on climate change. But the normative framework isn't necessarily talking exclusively about, you know, climate change and biodiversity. It's a bit broader than that. The normative framework is really trying to understand the relationship between the owner and the community through the thing that is owned. So I derive the social obligations not from the ethical or moral obligations of each individual owner towards their community, but it's more an obligation that is derived from what is owned. So in the case of land, and that's why I framed the research question as talking just about land and land use, because land, of course, has immense and diverse values for owners. So you could try to test this framework with other problems as well, and that's also one of the ambition to develop a normative framework that, you know, affects doctrinal understandings and can be used to solve at least partially the problems that I intended to solve partially. But at the end of the day, I also think that the normative framework can be used for other purposes. Because in the first parts of your question, you were talking about, you know, can we develop an understanding through Aristotelian political theory about the rights of nature, or about the problems that I tried to address, and I definitely think that's possible. It was just not within what I was trying to do, which was trying to understand better this this three-part relationship between the owner and the community and also the thing owned, and maybe not as a central actor, it's not a central actor in the normative framework, the problems that we might be facing. You solve the problems through the normative framework that has these three components, really. I hope this at least answers some parts of your questions.
May I quickly follow up?
Yeah.
Just one follow-up question. So if I understand correctly, would you understand in your normative framework the environment as part of the community interests, or would you say this is just not a question I answer in my thesis? Because I think there are two different readings of your thesis. Indeed, some parts it becomes very general, and in some parts it becomes very concrete on sustainability. And sort of, if you want, my question is, can you align them within your question or within your thesis, or is this just not interesting for you to deal with, and you leave this to further research? Yes.
Yeah, it's of course very interesting and a bit complicated. So I on the question of whether it's included in the community interests, I would say generally yes, but you could probably, make the argument that you might have cases where you have, and I talk a little bit about this in the case study where I talk about countervailing public interests. You might have public interests on the other side that are saying, well, you shouldn't do this. You should at least try to ameliorate this because, for instance, I talk about generating more power to generate more electricity, to generate cars and etc. But at the same time, when you're building like hydropower plants like in Iceland, you're ruining natural environments at the same time, which isn't really, so the question of sustainability isn't really a binary one where it's either sustainable or not sustainable. It's kind of a spectrum, even an algorithm, when it comes to making decisions that further sustainability concerns. So I'm not really, answering this yes or no, unfortunately, because I would say it's not directly within my framework, I would say that, but that it usually is a part of the community interest, but there may be, different interests that call for doing less or doing a different sustainability action than the government is proposing.
The opposition will now be continued by Professor O'Reilly, who is Assistant Professor of Private Law at the Faculty of Law of our university, and who will raise her question as an additional member of the Opposition Committee. Please.
Thank you. Dear candidate, dear Víðir, I want to join in also congratulating you on this excellent PhD thesis, where you address the tension between constitutional protection of private property rights and the need for adaptation in law so that we can address time-sensitive and pressing social crises such as climate change. In particular, I want to focus on the normative framework you have developed in Chapter 3, where drawing on Aristotelian concepts such as political community, deliberation, and practical wisdom, you then argue in Chapter 5 for a reasonable decision approach to proportionality. There, you have outlined 6 steps in this approach and also a shift in the strictu sensu analysis from balancing public interests versus private interests to deliberating about the justification behind and effects of a regulation. So, concerning the strictu sensu analysis, you propose that there will be an overall assessment of all relevant circumstances. First, in my understanding, by focusing on the justification for the regulatory action, so this is from the perspective of the community, and second, the potential effects of the regulation on private and public interests. And these adaptations to the constitutional protections against regulatory excess are therefore a move towards a more substantive, deliberative process, as well as a move away from this mechanical balancing of public and private interests. I very much want to agree with these adaptations that you propose as a pathway for overcoming the regulatory inertia that seems to be so characteristic of legal responses to climate change. However, I do have some concerns about the broader consequences for society if the reasonable decision approach and this adaptation of the strictu sensu proportionality test are adopted. how can the reasonable decision approach that you propose prevent the deliberative process from becoming captured by powerful lobbyists and the interests of the powerful few? And these are those that have the resources to monopolize the participative democratic process you envision in steps 4, 5, and 6. And to this, you have already pointed to the stricto sensu analysis in a previous answer. And therefore, I want to ask, well, this is my question. By positioning the judiciary as a check to whether a reasonable decision was reached by the polity, does this not push the problem further down the line by obligating the judiciary to become the final arbitrator for what constitutes as the common good? And as you've said, if courts operate within pluralistic rather than cohesive moral communities, what guidance can an Aristotelian normative framework offer the judiciary in reaching a reasonable decision? And if this is not possible, how would you respond to my challenge that this exposes a limitation in translating Aristotelian virtue ethics into the decision-making and governance of modern constitutional democracies?
Esteemed opponent, thank you for the question. When it comes to the stricto sensu analysis, the primary purpose of my modification in that step is to relieve the tension of the analysis. Because in the current framework, it talks about balancing public and private interests. And balancing really means, prioritizing one over the other, usually. And it kind of, pits the individual against the community. It kind of looks at public versus private interests as something that, is working against each other. And my suggestion is really to say, well, we shouldn't really look at it this way. We should look at it more amicably. And we should try to really understand what we are trying to do in this step of the proportionality analysis. And my answer is that we are trying to protect owners from what I call like unfair surprises. We're trying to provide them with a level of stability, but this level of stability, of course, can't depend on the circumstances, can't depend on numerous factors that I tried to explain. And I also mentioned that my thesis doesn't answer it once and for all how we should do the stricto sensu analysis, because it's a very complex question, but I tried just to outline what I think are the most important factors within this analysis, which I think is how much stability we should award owners. That's one thing about the stricto sensu analysis. And the reasonable decision approach is really a modification to the third step, to the necessity and the least restrictive alternative test. And I genuinely believe that approach is better than the necessity test when it comes to powerful lobby groups. Because as I also indicated in my earlier answer, today the lobby groups, the lowest hanging fruit for the lobby groups is the least restrictive alternative test, using that as a threat towards regulatory changes. And it's such an easy low-hanging fruit. And that's also the problem. And just also to be clear, I'm not suggesting to take the necessity test away entirely in constitutional law. I'm just saying that in the context of property, it's especially harmful. Because when it comes to, the right of life, the right to be free from torture, freedom of expression, you can still, apply the necessity test. And I think it's important because these are not, at least in this part of the world, we're not violating these rights frequently. It's a couple of decisions, maybe a year, and then the necessity test is fine. But when it comes to the, you can see.
You may briefly conclude your reply.
Thank you. Yeah, I think the necessity test is important there, but the difficulty about property regulations is that they are so frequent. Most regulations, they affect And they affect distributive justice. They adjust the burdens and benefits of society. That's really what regulations do. And because they are so frequent, this low-hanging fruit of threatening them with the least restrictive alternative test, is actually very effective. And I hope, yeah, I've answered the question in part, at least.
Víðir Smári Petersen, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company, both here and online, await the results of our deliberations at our return here in this room. Víðir Smári Petersen. The degree committee here present has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taken into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Akkermans is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisor to take the floor.
All right, please.
I first have a question to ask you. Do you promise to work in accordance with the principles of scientific integrity at all times, to be careful and honest, transparent, independent, and responsible?
Yes, I promise.
By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Víðir Smári Petersen, the degree of doctor and grant you all rights attached by custom and law. As evidence of this, your co-supervisor will present you with the degree certificate signed by the rector, the secretary and the other members of the committee and affixed with the official seal of the university. Dear Dr. Petersen, dear Professor Dr. Petersen, dear Víðir. In the Netherlands, there is a grant scheme for researchers called the NWO Talent Program, named after the letter Roman Emperor Julius Caesar sent to the Roman Senate after his successful military campaign. There are Veni, Vidi, and Vici scholarships available for researchers in the Netherlands. Over the years, I have, of course, participated in these schemes, and therefore I have an extensive archive on my computer of all these activities. However, in the past 4 years, I have almost every week looked at a folder structure on my computer called Veni, Vidi, Víðir. It is hard to explain how incredibly fitting that is today. You wrote me a little over 4 years ago after I published something on sustainability and property with the idea that you may want to write a PhD in this area. We spoke online, and before we both knew it, we had embarked on a project. In true Víðir fashion, you produced a proposal and then the first chapters faster than the speed of light. You can write so incredibly fast and incredibly well that you have made both Daniel and I envious at most times during the project. At the same time, you are a calm and very deep thinker with excellent reasoning skills. One of your major qualities is being able to take in a lot of information, including difficult feedback on your work, process this, and then come back with a 50-page chapter in only 2 weeks. This is perhaps one of the aspects that surprised Daniel and me the most. Over the years, we have kept saying this to each other. We have been so lucky to have met you, and it's been an absolute inspiration to work with you. With your incredible intellect, combined with an amazing sense of humor, very Icelandic at that, we soon learned, and immense general knowledge, you taught us an incredible deal about your home legal system, including how most Icelandic people know each other. I learned this in Southampton when you were convinced that Iceland would win the Eurovision Song Contest. And that, of course, you knew this Icelandic artist too. Before, we had already learned more on these close connections as you had brought half of the Icelandic Supreme Court with you to the Alps Conference in Southampton. Some of them are here with us today. Over the years, we have tested this theory, and I've become convinced that it's really more about you than about anything else. I am sure Icelandic citizens have a close rate of knowing each other, but it seems that everyone knows you, and you know everyone. Everyone you meet is impressed by you and always remembers meeting you and what you said to them. This is not to say that the trajectory we have embarked on together was an easy process. We pushed you hard, and you pushed yourself even harder. We had long conversations about the direction of the project and the research methodology. When doing property theory and reading the actual Aristotle, we had our first very serious conversations about what it means to be an academic. The solitude, the loneliness of the very hard theoretical and progressive work, and how to get this project across the finish line. You handled it like a pro. We changed course a little bit, doubled down, and before we knew it, we were on the final straight. You did all this whilst working full-time in Reykjavik, also running the university casino, if I'm not mistaken. And all this meant that your family had to miss you while you were working on all this. Many times we spoke about combining professional and private, the joys of fatherhood and the fears that come with seeing your children grow up. Although my son Jasper wants me to say today he demands a rematch in Mario Kart. Not in the last place, therefore, your success is also your family's success. And we are incredibly happy that they're here with us today and share this important moment. I understand Disneyland is in the near future. Dr. Víðir, my friend, it has been an absolute joy to serve as your supervisor. I have perhaps learned more from you than you from me, as perhaps should be the case in any good collaboration. I am delighted that we are continuing to work together on our A1-P1 projects. I cherish our friendship, and I am happy we now work on projects that require intellectual, but at a different pace of time commitment and pressure. I've seen you look much more rested and speaking about family life recently than ever before. Many congratulations to you, to your family, to your friends, and may our connection be only the beginning of more wonderful things to come.
Dear Dr. Víðir Smári Petersen, also on behalf of Maastricht University and its Faculty of Law, many congratulations on the degree that you just acquired. I always say it's the highest degree we have available. As a law school, we greatly value both our Dutch and international profile, and it's wonderful to see that you are our very first doctor from Iceland here obtaining the doctor's degree at this university. Congratulations, many congratulations also to your family and friends, both here and participating online in the academic ceremony. I have one practical remark, which is that there will be a reception offered by the young doctor here in this beautiful building. It will take place in the Refter. We will go there. I ask all people here in the audience to give priority to the cortege when leaving the aula, because we will still do one very important thing, and that's the taking of the traditional photo of our new young doctor, together with his paranims, with his supervisors, with the entire committee, and with our beadle, and we will do that at the stairs here of the building. Congratulations again, and with that I also officially close this academic ceremony.